started now.
Practice.
Okay.
Whenever ready.
Okay, I want to thank everyone for coming out to this event. It's going to be our last Federalist Society event of the semester. It'll be my last event organizing as the president. Really, I apologize for the smallness of the room. Originally, we're in Baker. There was some scheduling mishaps.
It's cozy. It's cozy. It's
threw
good.
us in here. So drawback, it's like Professor Blackman said, it's cozy. Positive is though there's no class here till 3-something. So if the conversation is good, it can continue. So with that, let's just get started. So the debate on DACA, or Deferred Action for Childhood Arrivals, is an important one the country is having right now. Proponents of the program, which was created in 2012 via Obama administration executive order, argues that it allows participants to enter the job market and contribute to the economy for the benefits of all. They can obtain driver's license, enroll in college, pay income taxes, and even serve in the military. Critics, on the other hand, of the program argue that a legislative solution for this specific class of people should be found in tandem with an overall comprehensive immigration reform package. Some also go further to say that having a program such as this may be effectively a moral hazard, encouraging more illegal immigration to the United States. Currently, there are a number of lawsuits that have been filed in federal courts throughout the country challenging the Trump administration's efforts to rescind the program. If I'm not mistaken, professors, to date, there's been a preliminary injunction issued in the UC Regents case that remains in effect, and DACA recipients are eligible to continue to apply for their DACA status. So with that set up, to my left is Professor Joshua Blackman. He's Associate Professor of Law at the South Texas College of Law in Houston. He specializes in constitutional law and the intersection of law and technology. He's the author of several books on the ACA, Obamacare, and has also testified before the House Judiciary Committee on the Constitutionality of Executive Action on Immigration and Healthcare. He's written over 4 dozen law review articles, and his commentaries appeared in several national publications. To my right, for those of you who are not familiar with him, is Professor Carlos Gonzalez. He is the Professor of Law and Herbert Hancock Scholar here at Rutgers. He's practiced in litigation employment law at Orrick, Harrington, and Sutcliffe in San Francisco before joining the Rutgers in 1997. His current research includes such topics as statutory interpretation, Article I legislative powers, and federalism. And he's also written several publications on these topics. So with that all being said, help me welcome our guests.
Thank you so much, sir.
Thank you. Oh, I'm sorry. And
Come on, you stole my thunder.
I'm sorry. I was going
Take
to
it
lay out
back.
the format for the debate.
Oh, that's fine.
But so 20 minutes for each side, and then 5 minutes for rebuttal, and then we'll open it up to questions from the audience.
Okay, thank you so much, Carlos. Carlos and Anthony for inviting me. I am from Staten Island, so I'm very close to home. It's always good to be back. Staten Island. Where'd you go to high school?
Portsmouth.
Anyone else? All right, I went to Staten Island Tech, so all right. Let me start off the debate by giving a couple policy points. I'm in a weird spot. I like DACA. I like the DREAM Act. I think these are very good policies, which I wish Congress would enact 5 years ago. Regrettably, Congress hasn't. My views on immigration, though, as a matter of policy, are often in tension with my views on the legality of these policies. It's often the case where I think something is a good policy, but the president can't do it. And there are other cases where I think this is a terrible policy, but the president can do it. So I'm in sort of this weird middle-of-the-road position. I want to begin by walking through some history. To understand the current debate about DACA, we have to go back several years. And I'll start in 2012, which is about as good of a place as any. In 2012, the Obama administration announced a policy. This policy is known as DACA, Deferred Action for Childhood Arrivals. Now, let's be very clear. This was not amnesty. It wasn't. DACA did not provide citizenship. It did not provide even a pathway to citizenship. That was the DREAM Act, which was legislation that made it through one branch but didn't make it through the other branch of Congress. So again, DACA was not some sort of executive amnesty. It did not provide citizenship or path thereof. But here's what it did do. It relied on a practice known as deferred action. Deferred action isn't actually defined specifically in a statute, but it's kind of built on executive practice. And the notion is that Congress has finite amounts allocated for removal, right? There's only so much money they put in every year for removal. It would be impossible to actually apply the immigration laws to every person in this country who's subject to them. It's just legally and financially not feasible. So the government always has to make decisions. We remove this person, we remove that person. What DACA said is we will now exercise our prosecutorial discretion in a specific fashion. That if you came here as a minor, you played by the rules, you didn't get in trouble, you graduate from school, you pay a fee, you go through a background process check, we will deprioritize you from removal. But wait, there's more. It didn't only affect the deprioritization of removal, it also granted certain benefits. For example, the ability to work and receive other sorts of federal benefits. Critically, it gave something known as lawful presence, and this is kind of important. The designation of lawful presence is what triggers a host of other benefits that come along with it. Okay. When DACA was first announced in 2012, I think Carlos would agree, the reaction on the right was somewhat muted. There wasn't a huge outcry, which in hindsight, and maybe surprising, but you didn't have the same sort of let's go to court that you had a couple years later. There were some small challenges to DACA, but they didn't really go anywhere. And sort of the policy was in effect for 2 years, and it was popular. People liked it very much. Okay, let's fast forward a bit. 2014. During the spring and summer of 2014, there was hope that Congress would pass comprehensive immigration reform. Indeed, the bill actually passed through the Senate, which was not a guarantee. The bill was then sent to the House. In what was, I think, a preview of things to come, the House leadership, Speaker Boehner, did not even bring the bill for a vote because he realized his members would be killed if they actually had to vote on this thing one way or the other, so they just let the bill die. After the House refused to vote on the immigration bill, President Obama had a press conference where he said, I'm paraphrasing, if Congress won't take action, then I will. Okay? Several months later, after the midterm elections, President Obama announced a new policy known as DAPA. So you have DACA with a C and DAPA with a B. It's a deferred action for parents of Americans and lawful permanent residents. It's actually DAPA, but just called DAPA for short. Okay. DAPA differed from DACA in one important regard. It didn't apply to the dreamers themselves. It applied to the parents of U.S. citizens and the parents of lawful permanent residents, a green card holder, to make it simpler. And it gave the same sort of benefits. If your child was a citizen and you met certain conditions, you didn't have any criminal history, whatever, they would give you deferred action status, they would give you lawful presence and work authorization, et cetera. Okay. DACA wasn't that controversial, but DAPA sure as heck was. And the state of Texas, the Attorney General, announced a lawsuit that they would challenge the legality of the DAPA policy. Okay, they would challenge the legality of DAPA. So what happened? They filed suit in Brownsville, in the Southern District of Texas, and it was gross forum shopping. I'll be happy to admit that. There's no way around it. They picked a forum where they think they got a favorable bench, which, I mean, to be frank, you'll all be lawyers soon. You pick favorable forums, right? If you're a lawyer and you pick a bad forum, your client should probably fire you. If you want to be in state court, you stay in state court. So this is not unconventional, but it was forum shopping. And they argued that the Obama administration lacked the statutory authority to rescind DAPA. They also argued it was unconstitutional. I'm sorry, to enact DAPA. And Texas also argued that the policy itself was unconstitutional, that it violated the Take Care Clause of the Constitution. Now, when I used to do this years ago, no one knew what the Take Care Clause was. Now people do, right? There's an obligation for the president to take care that the laws are faithfully executed. And Texas argued that this was effectively a suspension or a failure to enforce immigration laws as to a fairly large category of individuals. Okay? All right. The district judge in Brownsville, Texas, entered what is now known as a nationwide injunction. They weren't so known back then, but now we all know nationwide injunction. He said you have to block the enforcement of the DAPA policy. It was appealed to the Fifth Circuit, and the Fifth Circuit agreed. And the Fifth Circuit held that the DAPA policy was not supported by statutory authority. The court did not reach the constitutional question. Okay. After some procedural wranglings, which are not important here, the Supreme Court took up the case. When the Supreme Court took up the case, when they granted certiorari, there were 9 justices. However, when the arguments were held, there were only 8. Justice Scalia had passed away during that period. He died in February of 2016, if my memory serves correctly. So as a result, only 8 justices resolved it, and the court's resolution was unsatisfying to everybody. We got a 4-4 tie, right? When the justices split 4-4, there's actually no opinion of the court. There's no analysis. It's like a one-sentence order saying the court affirms the lower court by an equally divided margin. The key word there is affirms. As a result, the Fifth Circuit's opinion became the law of the land, so to speak. Okay, well, that was, I guess, June of 2016. At that point, I expected, and everyone expected, Hillary Clinton to win, and Merrick Garland would replace Scalia, and that these policies would be just fine. And I'm sure the members of the court thought basically the same thing. So, whatever, we'll wait a few more months, and President Clinton can bring this back up later. Okay. Trump won. He won the election, and then he put on Neil Gorsuch to replace Justice Scalia's seat. But he did more than that. President Trump rescinded DAPA, right, the parent policy. That didn't really have much of an effect because it never really went anywhere, right? No one had DAPA, so to rescind that policy was like whatever. It didn't change the status quo. But critically, initially, the Trump administration left DACA in place. And this is one of the big enigmas and the riddles, right? The Trump administration, left to its own devices, was saying, okay, we'll just keep DACA in place. Even though probably half of the lawyers in the Trump White House said this thing's illegal. But then Texas, my home state, comes back into the fore. Texas sends a letter to the Attorney General saying, we've concluded that DACA is illegal, and here's an ultimatum. You withdraw DACA, or we're going to sue you. And we're going to challenge DACA as unconstitutional. If you don't pull out the policy, we're going to sue you, right? So this is weird, right? It's Republicans suing Republicans, right? The optics here are very unusual. Okay, so what happened? Over that summer of 2017, the Trump administration thought it over, and Attorney General Sessions released a memo. It was a fairly short memo, which I'm sure we'll talk about a lot more later in the presentation. But the memo basically said, we are withdrawing the DACA memo. And he offered a number of reasons, which I will get into later, explain why he thinks it's no longer illegal and that this is not something he wants anymore. The reasoning actually becomes important when we get to the rescission, the cancellation. Okay. Almost immediately after the Attorney General withdrew it, lawsuits were filed across the country. In fact, they weren't even new lawsuits in some cases. They were just continuations of old lawsuits. There was one in Brooklyn, right, in the Eastern District of New York. There was one in the Northern District of California, filed all over the country. And these were brought by DACA recipients. They were brought by universities that DACA students study at. They were brought by various nonprofit groups. The entire range of advocacy groups brought these lawsuits. And they made several arguments, right? They said that the decision to rescind, that's cancel, the decision to rescind DACA was itself unlawful. Now let's just start some basic principles. Everyone agrees that there's no constitutional obligation for President Trump to keep in place a policy that President Obama had. I think Carlos and I would agree on that emphatically. The question is whether the government had a adequate, a sufficient, justification to withdraw the old policy and put in place a new policy, right? That's the entire question. It's not whether is Trump saddled with Obama policy for the rest of his life. No, that's not the issue, right? It's whether he had the requisite justification. There's a second question, which at least a couple of the district court addresses. Was it unconstitutional for President Trump to withdraw the policy because he acted with an improper animus, a hatred of Hispanics? And I think at least one or two courts actually reached that issue. I think the one in California did, right? I think
they allowed that
Yeah.
claim to proceed.
Yeah, thank you. Yeah, I can't keep track. There's so many lawsuits floating around. I always get them confused. And the argument's this, right? It's basically like the travel ban, but for Hispanics. The argument is, President doesn't like Hispanics, and the reason why he's withdrawing DAPA is because of an animus, a hatred of people of Hispanic descent. And I think like 90-something% of the DACA recipients are of Hispanic descent. Okay. So let's actually get into it. California, New York, these various courts are now entertaining the question of whether the DACA decision is illegal. And so far, I think not every court, but just about every court to address the issue has said that President Trump did not adequately justify the decision to cancel DACA. I think one or two judges upheld it, but sort of a moot point, because if you have nationwide injunctions in court 1, 2, and 3, and court 4 says, nah, that's fine, it doesn't have any meaningful effect. Okay, but let's not forget about Texas. Texas indeed went ahead and sued the Trump administration, arguing that DACA was unlawful. And as happens elsewhere, the Trump administration said, yeah, we agree, right? We agree. So now you have interveners, MALDEF, which is the Mexican American Legal Defense Fund, and other groups are suing in Texas to defend the DACA policy. That case is still pending. The district court in Brownsville has been sitting in this case now for, what, 6 months? It's been a while. I'm not sure exactly what he's waiting for. It's a summary judgment motion. It's just sort of sitting around the docket. The reason why I want to tee this up is the Supreme Court has actually stayed out of it so far. They haven't had to intervene, right? The Supreme Court has not had to intervene, precisely because there's no split. The Solicitor General tried to run to the Supreme Court last year and say, we need to resolve this now, and the Supreme Court said, go away, come back later, right, when there's a split. But if, it's a big if, the district court in Texas and the Fifth Circuit Court of Appeal says, yeah, we agree with Texas, DACA is illegal, then you have this split of authority, right? You basically have what I call dueling nationwide injunctions or dueling cosmic injunctions, where court number 1 says you have to continue enforcing this policy, and court number 2 says you got to stop because the policy itself is illegal. And this, I think, would create, the Supreme Court would immediately have to intervene. So all the sort of lower court wrangling, I think, is just a prelude to see what happens in Texas. And Texas, again, says you can't do this. Fifth Circuit says you can't do this. At that point, I think the Supreme Court has to intervene. All right, now let's go back to the actual legal question, right? Can President Trump and the Trump administration cancel or rescind DACA? And here, I'm actually going to express some sympathy for Carlos's position. I think they've done some lousy lawyering. I will be the first person to admit this. In this case and elsewhere, the Trump lawyers have not done a good job. Okay. Had Jeff Sessions issued a letter that says, you know what, I think that DACA is no longer a good use of resources, and I want to change our priorities. This is not something we want to do anymore. I think Carlos would agree. I mean, you could disagree with the judgment. I think that would be okay, right? He just said this is not a good use of our resources. We want to change our enforcement priorities. That's it. He didn't write that letter. I can't tell you why. I wish I knew why. That would have been made so much easier, right? It would have resolved the constitutional question about animus, but it made it easier. Instead, he wrote this other letter, and I'll summarize this. It's a little bit wordy. He says basically, I've come to the conclusion that DACA is illegal, that I don't have the authority to do it. Right? I looked at the Fifth Circuit opinion about DAPA. I think it's right, and that suggests that DACA is illegal as well. Here's a legal question. Any administrative agency has to act in a way that is not arbitrary and not capricious, right? This is a big standard, A and C, right? Arbitrary and capricious. And the courts so far have said that there's been really one reason why they said they want to rescind it. It's not legal. And the courts have said, if Sessions is wrong, in other words, if the policy is legal, then his memo is arbitrary and capricious. In other words, he gave one reason, The reason is it's illegal. If he's wrong about that, he is not given a valid, a justifiable reason why the policy has to be rescinded. Right? That's what the courts have said so far. And this is where I think Carlos and I are going to part company a bit. When the courts are applying arbitrary and capricious review, there's a little bit of deference here that I think is not being applied. The Attorney General, Sessions, argued that this is not only without statutory authority, he suggested in sort of an opaque way, and it's a lousy wording, that this goes against the president's constitutional duty to faithfully execute the laws. Okay? The courts haven't given that statement, I think, the weight it's due. In fact, they've ignored it. One judge actually cited me. He cited one of my blog posts. He said, hey, Blackmun's making these arguments. DOJ, why aren't you making Josh's arguments? I can't tell you. That's why. But if you give more credence to the president's constitutional obligations and the AG advises on this, I think that's enough to give her the hurdle. But again, I think we have some lousy lawyering. Indeed, one of the other judges in D.C. gave them a second chance. Said, give us another memo, right? Give us another justification, please. And they just sort of just spilled the same stuff without any meaningful changes. So I can't tell you for the life of me why DOJ is litigating the case the way they are. I don't know. What I do know is that there are valid and justified reasons to cancel this policy. They just haven't been given in court. And if we stick with this justification, it's illegal and that's it, then that's putting the Supreme Court in a tight spot. The Supreme Court has to say, okay, we agree it's legal, or we disagree it's not legal, it's illegal. And then the court has to resolve a very messy constitutional question, okay? The second part, and I'll turn over in a minute, the second part I want to talk about is the sort of Fifth Amendment equal protection, right? This is the idea of animus, right? You talk about this cases like Romer v. Evans and Kleber and other cases like this and the travel ban. Here, I think the president might be in a little bit more trouble. We had a situation with the travel ban where the court basically said, we're in the area of foreign policy. We have these statements from the president, but we can't really give them that much weight because the president has a duty to keep us safe in foreign affairs. On the flip side, this is domestic, right? This is domestic policy, not foreign affairs. So I think you don't have the same sort of immunity that the president might invoke. But the flip side is you have a lot more attenuation, right? The president said on the campaign trail, I want a Muslim ban. Then he hit on the president, okay, well, this regional travel ban. Here, the statements are more attenuated. For example, like he said, talking about Mexican Americans and building a wall and Jorge Ramos, all this other stuff. I think you need to show a lot more connection between the statements at issue and the policy to justify it. Indeed, the president has basically said, I love Dreamers. Maybe he believes it, maybe he doesn't, who the hell knows. But I think it's going to be harder to make the same sort of animus finding. But of course, the intent here is to get discovery and try and depose the president, which is always what people want to do. So he perjures himself in 5 seconds. It's true. Happy Mueller to everybody. I've skimmed most of it, at least. It's been a 500-page PDF that you can't Control F. That's evil. That is an obstruction of justice to put a PDF that you can't search. That's awful. All right. I think I've said enough. I think we'll have a nice back and forth. I think that lays the groundwork, lays the basic framework of where we are, and hope we have a very nice discussion. Thank you all so much.
There's so many issues that I hope our interchange will get into. The DACA litigations, it touches on statutory issues, it touches on Administrative Procedure Act issues, it touches on constitutional role of the courts and the powers of the president. And so I'm not gonna, I know that I'm famous for trying to fit too much in. I'm gonna try to fight that tendency and just hit some highlights, and then that will open the door, hopefully, to questions and also interchange between Professor Blackman and myself. Okay, so I want to talk about 3 things. I kind of want to put DACA, but I guess DAPA also fits in this, into a broader framework, so you can sort of see how it kind of fits in to this phenomenon of categorical non-enforcement. So I'll talk about that for a minute. And then that leads into some issues that Professor Blackman was talking about the legal foundations of DACA, and I guess we could also bring DAPA into it, and Fifth Circuit opinion into the Texas versus United States case, and then finally these cases that are now running around where the Trump administration, Department of Justice and the Department of Homeland Security tried to withdraw the DACA policy. Okay, so let me begin with this question. Now, almost everyone's going to raise your hand. I hope we don't have anyone who can't raise your hand for this. Who here has a place that you call home? Everyone raise your hand. Up high, up high. Okay, keep your hands up. If you do not have marijuana in the place you call home, put your hands down. Okay. I know.
Snitches get stitches.
So,
Snitches get stitches, everybody.
I'm sure that some of you do actually have marijuana in the place where you go and sleep and you call home at this point in your life. How many here have had federal authorities crash into your abode where you store your Schedule I Controlled Substances Act marijuana and subject you to federal prosecution? Good, none, right? The Department of Justice is under enforcing federal law. They are not fully enforcing the Controlled Substances Act for all of you. But those of you who don't smoke marijuana or any other Schedule I, the other things, other federal laws you've broken, and we might find one person here, or maybe none, who have been subjected to federal prosecution. So this phenomenon of the executive branch not enforcing federal law is ubiquitous and it's unavoidable. And that then gives rise to the need to sort of decide some enforcement priorities. What parts of the federal law and under what circumstances will limited enforcement resources be used to do what can be done to enforce federal law? And so sometimes these happen on an ad hoc, sort of decisions about enforcement priorities happen on an ad hoc basis, and low-level bureaucrats formulate their own standards, their own approaches to this. I told a story last week to my common law students about, I live in Hudson County, North Bergen, and I was pulled over last fall. And in the discretion of the officer, even though I was going over the speed limit, he did not issue me a ticket. This is declining to enforce the law. It's something that is common, and he had his own reasons, his own standards. He might have been instructed by the police chief or even the mayor, don't write tickets to people that live in our town. That would be a categorical, right, non-enforcement type of approach, and that is also pretty common. I'm not going to go through this too much, but I apologize for making new slides, but I just want to use a couple that I use in a course I teach on Article 2. Good, we're getting issues. So this is an example of categorical non-enforcement. Now it turns out that in Internal Revenue Service tax collection, categorical non-enforcement is everywhere. It is ubiquitous and it is unavoidable because Congress has not seen fit to adequately fund, even close to adequately fund the IRS's enforcement capacity. So here's a simple, easy to understand issue: frequent flyer miles. This is under the federal tax statutes. This would count as taxable income, but you see here the IRS in 2002 is people have to do their taxes at the end of the year, and their accountants and their tax attorneys are, what do we do about my frequent flyer miles? Is that taxable income? And the IRS just issues public guidance. We're not going to enforce that. Yes, it probably counts as a taxable income under the statute, but we're telling the world we're not enforcing that. Go about your business. Okay, so that's an example, and really DACA is sort of very similar to that. You need to set enforcement priorities, and that's what we're going to do. Let me give you one a little bit closer to DACA, which this comes from the immigration area. This is another example of categorical non-enforcement. It so happens that really for quite a long time, Starting all the way back in 1882, federal statutes have denied legal permanent residence, which is, colloquially green card status, for people who, under the statutory terms, are, quote, likely to become a public charge. That's all the statute says. And at various points in time, and really ever since the statute was passed, the executive branch agency charged with enforcing the statute has come up with guidance on how to enforce that, and it under-enforces, has typically under-enforced, or for most of its history, it's under-enforced that statutory norm. And the details aren't important, but during the Clinton administration, the guidance just limited this public charge statutory norm to people who accepted certain types of federal benefits. But there were other types that people could accept and still not be considered a public charge. And so this was, it was categorical non-enforcement, more narrowly enforcing the statute than the actual statute would seem to call for. So that's, this sort of thing is, DACA and DAPA are really no different from the way our federal government works every day and has worked this way for decades and decades and decades. It just happens to touch on an area that is of political controversy, and it also happens to touch on an area that, especially when you loop not just DACA, which reaches about 700,000, but also DAPA, perhaps up to 4 million of the 11 million undocumented persons reported to be residing in the United States. So it's bigger in size, right? But again, there are a lot of people with frequent flyer miles. A lot of folks. You might have some. And with tax day just passed, I'm sure that TurboTax did not make you report your frequent flyer, or if you have a tax accountant, and because they have been told by the IRS, given this guidance, we're not going to enforce that part of the federal law. So that's really, I want to put it in that broader context. This categorical non-enforcement is common, it's ubiquitous. DACA and DAPA, and I'm sure Professor Blackman's going to try to distinguish them in a minute, but it's pretty much the same as what happens every day. And so, but I'm hoping we can get into some take care clause arguments. It gets sticky when you want to interpret the take care clause of the Constitution to require the executive branch, the president, or in this context, Department of Homeland Security with immigration law, to maximally enforce in all possible instances removals of people who are under the statutory norms are actually removable, are not do not have proper documentation to be present in the United States. And let me also just make this point, which is, if I can, this is just from just a public press article, 538.com. 39 examples of deferred action over the last 58 years. And I think Professor Blackman might try to distinguish DAPA and or DACA from some of these, but
I will.
Deferred action it's better, just looking in the immigration context, and at this sort of, you have categorical non-enforcement, and deferred action is a subcategory of categorical non-enforcement. But just looking at the subcategory in the immigration area, it's been going on for decades. And many, many times, most presidents have used one form of it. One that I'll point out originates in the Reagan administration and was greatly expanded in the Bush administration. And again, the details I want to sort of stay short here, but one little detail that I want to get at, yes, here it is. If I can, it's 40% of the then undocumented persons residing in the United States were covered by the expanded Family Fairness Program. That's pretty close to the number of undocumented persons that would be covered under combined DAPA and DACA. So you just had a gross smaller number of undocumented persons at the time than we do now, but by percentage terms, this was categorical non-enforcement, deferred action, a form of deferred action, that wasn't contrary to the statute, but there was nothing in the statute that specifically addressed this. And it started with Reagan, and then the first Bush, after Reagan, expanded it to cover huge numbers of undocumented persons. So I now want to talk a little bit about the legal basis, just very quickly, and this will just, again, kind of open the discussion. Congress has given the executive branch of the Department of Homeland Security the power to establish enforcement priorities. And here, let me switch to the two key statutory provisions that delegate this exact power that the Obama administration exercised. So first, 8 U.S.C. 1103. This is the key delegation clause in the Immigration and Nationality Act. It gives the department, not only just allows it, but it says shall establish such regulations, issue such instructions, so on and so forth, necessary for carrying out the authority under this provision. So it's a broad delegation, but even more narrowly, in 2002, when Congress reorganized the federal bureaucracy in the wake of the 9/11 attacks to deal with the perceived shortcomings and different agencies not talking to each other, and established the Department of Homeland Security, this section was passed in that statute. And it specifically, it doesn't just say you may, it says you shall be responsible for establishing national immigration enforcement policies and priorities. So there's a clear legal basis for categorical deferred action non-enforcement. Congress gave the Department of Homeland Security that power explicitly by statute. Presidents have used it for decades in various permutations. There's nothing new here. It's no different than the IRS saying we're not going to fully enforce the tax code. There's certain categories of income. We're letting the world know, just to keep life simple and because we have limited enforcement, we're not going to go after you on those things. Not your frequent flyer files. There are dozens of others that the IRS issues guidance on. And I guess I'll stop there. Maybe we can open it up for exchange, and that leaves open. It's still, I want to get into this question of the Trump administration seeking to revoke DACA, and I understand that this is an issue of time. I want to
People have class now?
exchange.
Okay. Okay. All right. I'll start here. Thank you so much, Carlos. That was excellent. Let's start here. 6 U.S.C. 2025. The Secretary responsible for establishing national immigration enforcement policy priorities. Okay, Carlos says that's clear delegation of authority. I don't see that's very clear. I think it's a fairly open-ended delegation, which doesn't tell us much. Now, let me make one point. There are decades of history of presidents using deferred action. Unfortunately, those statutes were repealed in 1996. In 1996, Congress passed a massive immigration bill, the IREA. I can never say that damn acronym, but it's a huge immigration law in 1996, which changed the law. It actually scaled back the president's discretion for deferred action. The Obama OLC explained that deferred action must exist within certain confines, right? And they looked to about 4 or 5 different past exercises by the George W. Bush and by the Clinton administration that were within the bounds. And let me just give you a synthesis, right? In 2005, Hurricane Katrina hit New Orleans. Imagine you were a foreign student there, right? You had a student visa, you were fine. Katrina hit, no classes, no credits, you lose your student visa. You are now in the country without lawful presence. So the Bush administration said, we will grant a temporary reprieve. We will give deferred action to students in New Orleans so long as they enroll in a university by the following semester, right? We'll give you deferred action. You can stay in the United States, you don't have to go back to your home. Okay? The key aspect of deferred action was it was used as a bridge. Someone had some sort of legal status and the other end of the rainbow, so to speak, right? It was always used as a transition. And through every instant post-1996, deferred action was used as a bridge where there was something waiting on the other side. DACA is not a bridge, right? When you get to the end of your DACA, 2-year, 5-year, whatever the period is, you're in the same spot. Unless maybe perhaps you get married or adjustment of status. There's nothing else in your paperwork that will allow you to become a citizen or get a green card, right? There's a huge difference between DACA and past uses of deferred action by the Clinton and Bush administration. Again, the 40% number, they actually interviewed the guy who said that. He said, we don't know where they got it from. That number was way expanded. It was never actually that many people. And I'm actually not even convinced that the Bush policy was lawful, but I'll table that for a minute. So we have a general statute that doesn't really say anything about deferred action. We have a fairly narrow history since 1996 of statutory practice. The Obama OLC acknowledged that DACA was on a more shakier footing, right? Why? I think in some regards DAPA is better. With DAPA, you at least have a parent whose child is a U.S. citizen. And when that child turns 21, that child can then petition for the parent to have adjusted status, right? I think DAPA is closer to the statutory framework. With DACA, the Dreamers do not have that pot of gold at the end of the rainbow when they turn 21. So I think even OLC acknowledged in this cryptic footnote that DACA is harder to justify than was DAPA. Okay. Now let's take a step back and talk more broadly about the take care clause. And this is a part of the Constitution we don't really talk about much. I'll give you an example. We talk about, timely. What gives the president the power to fire officials, right? Well, there's no firing clause in the Constitution, right? It doesn't say the president can fire anyone. But the courts have suggested that's a take care clause, which says the president shall take care the laws are faithfully executed, which allows him to fire people. Why? Imagine the president's subordinate, let's call him James Comey, right, who's screwing up the president's agenda. He says, I can't do what I want to do, so you're fired. Right? The idea is the president can fire people to ensure the laws are faithfully executed. That's usually how we understand the take care clause. But this side is the flip side, right? Is the president under enforcing the law? Now, I think the marijuana example is a good one. I've used it before myself, speeding tickets as well. If this case was different, right? If the president merely said, we are giving all the Dreamers a do not deport card, not a report card, a do not deport card, we will not remove you, I would not be making the same argument I'm making now. I think that probably would pass muster, and Texas agreed. The key point, though, is that the DACA policy grants lawful presence and hosts of other federal benefits. Now, the benefits are authorized by statute, by regulation. If you actually go back to the history of these regulations, it was understood that maybe a few thousand people would get this, right? Not hundreds of thousands, not tens of thousands, not millions. So I think we are, again, beyond the scope of statutory delegated authority. If this statute gave President Obama the power to enact DACA, this statute violates the non-delegation doctrine. Yes, that moribund doctrine from Schechter-Poultry. Congress cannot give legislative power without an intelligible principle. There is no intelligible principle to be had. So I think on both statutory, on both constitutional level, this policy is in trouble. But I temper that because it's real popular and people like it. And I think the Supreme Court's going to have a really tough time intervening to kill a policy that would result in some period of time from removal for Americans who've been here for some time. So this is a hard case, not just law, but I think also policy. And policy does exist. It does factor into these decisions. All right, I'll stop here. I'll sit down, and I think we have a nice discussion.
Let me just clarify. The bridge theory. Professor Black and others have said prior examples of immigration deferred action have always involved, I think they've always involved temporary deferred action when at the end of that period, under the statute, the persons who are within the group that gets the deferred action benefit would be able to establish legal permanent residence and then maybe eventually citizenship. That may be true factually, but there's nothing in the law that Congress has never passed a statute that said, well, to the extent you're going to use deferred action, it can only be used in the bridge scenario. I guess you could also say, kind of DACA, when it originally conceived, in a roundabout way, was probably intended to be a bridge to Congress passing some sort of statute reform that would grant some sort of pathway to citizenship for the Dreamers. And you could argue to say it's a little. I admit it's distinguishable, but at least as a policy matter, they probably thought of it as some sort of a bridge that we'll need for some time until Congress can get its act together and pass some sort of immigration reform. On the issue that the statutory delegation, it doesn't specifically delegate the power to use deferred action. I mean, that's obviously true, and you see the text right there. But it's a broad delegation. There's certainly nothing that says Congress has been aware of deferred action, has recognized deferred action in other statutory amendments. The Supreme Court has recognized its existence and never seemed to have a problem with the general phenomena of deferred action. So when you have a broad delegation, I mean, you guys all remember your non-delegation doctrine cases from common law one. Supreme Court just says, do whatever you want, as long as it's an intelligible principle. Now, I think that Congress doesn't have to delegate this power. The power to set enforcement priorities inheres in the executive branch. It's part of what is the nature of being the president, the chief executive officer of the United States government, and the head of the executive branch, and then under the president, the various department heads, including Homeland Security. But Congress did actually give the statutory delegation to set enforcement priorities, even though if they hadn't, I think there's a plausible argument that just straight under the Constitution, or separation of powers with the Constitution, you can set enforcement priorities. Again, it's done all over the place in just about every corner of the executive branch of the federal bureaucracy. They, of necessity, have to do it. And then the question becomes, well, how should they do it? What's the way to set enforcement priorities that makes the most sense? Do we really want to read the take care clause to bar public enunciation of categorical persons or situations of low enforcement priority and even deferred action? Do we really want to read the Constitution to require that only low-level bureaucrats, only the police officer who pulled me over, can decide, well, I'm going to let you go with a warning today, but the police chief can't? I mean, that sort of turns the powers of the president on its head. How could a field officer who's charged with enforcing immigration law have the power to exercise discretion, but the president not have the power, or at least the Secretary of the Department of Homeland Security not have the power to say, you know what, we need some order and uniformity in setting our enforcement priorities. Here's a memo. It still leaves you with plenty of case-by-case discretion, but here's some general guidelines and norms to follow, field officers. Why would we read the Constitution to give the low-level bureaucrat more discretion than the department head or even the president? I'll stop there.
Okay, we'll take some questions.
Yeah.
Please. Yes.
I hate using this framework, but these are two questions. One, in terms of Professor Gonzalez, I'm curious about what things look like on the ground and the idea that individuals who are enforcing the law on the ground are the measuring stick for enforcement itself, and how that can inform this larger conversation. And then on the other hand, I'm curious about even reading the statutory language establishing national immigration enforcement policies and priorities. While that's an establishment, I'm curious about what people think about the argument that doesn't necessarily mean that there's an enforcement mechanism in place for the Department of Homeland Security in that regard. It's just an establishment. You establish something, but what's the enforcement mechanism behind it? Is the Department of Homeland Security? Does the president come in? I'm just curious about those kinds of arguments.
Yeah. Okay, I'll take them. Thank you for the question. I'll try to take them in order that you asked them. So the first part is, in terms of like what do things look like on the ground. I'm actually very amenable to Carlos's argument that why should it be that low-level bureaucrats, I don't mean that pejoratively, but just line item agents should have more discretion to set priorities than the head of the department. It comes down to distinction between ad hoc and categorical. The OLC memo from the Obama administration said that in some regards, an ad hoc determination is less likely to be a suspension versus a cabinet-wide categorical approach. And the categorical approach feeds into the second part of your question, right? What are the actual means of enforcement that the agency has? Again, there's no statute that says deferred action. It doesn't exist in the statute. That's why we have to infer it from past executive practice, right? Talk about the gloss from Youngstown, so to speak, right? We don't have an actual statutory delegation. Executive practice exists within the statutory bubble. We ask, are we within the past practice or going beyond it? And I argue because we go beyond it, that's because the enforcement mechanism doesn't exist in this regard.
Let me just quickly respond to, going back to this I raised it earlier about persons under the statute, way back to the 1800s, who are deemed a public charge. What the Clinton administration found is that although there had been categorical guidance issued by prior presidents, but they found field officers kind of applying that public charge norm, that statutory norm, in inconsistent and ad hoc ways. And depending upon which region of the country and which officer would be dealing with your green card application, they might say, well, you are a public charge, and then 300 miles away, a similar situation, well, you're not a public charge, so here's your green card, right? So that's why you want to, if anything, I think you should read the Constitution and separation of powers to allow uniformity and also to encourage the executive branch to publish, as the Obama administration did with DACA and DAPA. These are the criteria we're using. DACA had 4, and then it purported to reserve case-by-case discretion. That's important to do to remain within what's legally permitted. But that's really what I would advocate. I would say that these questions of what does the take care clause mean? Does it allow, is categorical non-enforcement tantamount to executive statutory amendment, which some would argue would violate separation of powers? I would say that practically speaking, we're better off without the hidden categorical non-enforcement, which we definitely have. We have right now the Trump administration come in they appoint department heads, and they don't tell us the criteria, and Democratic presidents have done the same in the past, but they are applying criteria to under-enforce, to non-enforce. We're going to place more enforcement priority over here, less over here, none in a third category. What's great about DACA and DAPA is it tells us what's going to happen. It makes it transparent. There's greater political accountability. And the Fifth Circuit's opinion in the Texas case, sort of finding that beyond what's legally permissible, it just encourages the executive branch to hide their categorical non-enforcement policies, which they're going to have. We're better off as a democracy if they're not, if they're actually public. And we might even think about legislation that would require public enunciation of enforcement priorities. And sort of, I don't know if you want to apply that as a blanket rule, but you could think about it in different areas. Other questions?
So I'm curious, you brought up the issue, Professor Blackman, about bringing in, that Texas would likely agree to the fact that, we can provide that, do not work hard, and then, the issue is more with providing benefits, and that's the special precedent. But you actually briefly touched on this in your introduction, about the idea of a moral hazard. So what's the issue?
That was yeah.
No, okay. So if you could bring up this issue about a moral hazard in terms of what is the issue? If you agree, which I believe you alluded to at the beginning, that you kind of agree with DACA and DAPA in general. So what is a slippery slope for this moral hazard of
when he said moral hazard, I didn't agree with it then. It's not retroactive, meaning it only applies to people who entered before the policy was announced, right? So I don't see the moral. If it applied ongoing, that if someone entered today with their child, they would then be eligible for it, that would be a different story. But as I understand DACA, it only applies to people who entered before a certain date, before the policy was announced. So I don't see the moral hazard to this policy. But sorry. Yeah, that's fine.
Have you justified DACA then? Did you find that Britain had granted the amnesty? Have you justified it?
Well,
Going back to the moral and why not? If it will have
again, I don't adopt that argument. That wasn't me. That was the person who introduced me. Thank you.
So you're saying you.
I'm
you
pretty
reject- you
liberal.
say
I'm
that?
pretty liberal immigration. It's people usually don't believe me on it, but it's true. I would support the comprehensive bill that passed in 2014 and the DACA, the Dream Bill that passed in 2012. I take a pretty expansive view on immigration policy.
Yeah.
Why I'm usually in a weird spot I'm arguing other, but that's usually my life.
Well, can I ask you a question?
Please. Yeah.
Professor Blackman, I'm going to invite you to speak a little more expansively about maybe some of your ideas on how you read the take care clause and how it would apply in this situation and to these categorical non-enforcement. Where do you come down? I see a lot of different scholarship on this, and I can talk about some of the different theories that have been raised. I'm kind of going to invite you to see which box you fit in on that.
Right.
How would you think that the Supreme Court, if it ever comes up, should think about take care clause categorical non-enforcement issues?
Right, and I see people are moving, so I'll make this our last question. The take care clause does not have much litigation, so there's not a lot of case law to go on. When I was researching this issue years ago, I looked at sort of the history. A lot of early state constitutions, even before the U.S. Constitution, had clauses that resemble a take care clause, and basically said the governor cannot suspend the law. And this fear went back to King George III. There were many grievances in our Declaration of Independence. One of them is the king is suspending the laws. He's not enforcing the laws. And there was basically a power was called dispensation. He can just basically X out a law. So I think there's a general prohibition that the president can't ignore the laws of Congress. He has to enforce them. But of course, no law can be enforced 100%. It's simply not possible. I think the speeding ticket example, the marijuana example you gave, are all very good examples. I argued with a lot of trepidation. I made this argument very timidly. I think the Obama administration ran across the line because of the specific nature in which DACA came about and DAPA came about. Let me walk you through this, right? Congress considered a bill that would have done a lot of what DACA accomplished. Not everything, but done a lot, right? No citizenship, but done other things. That bill didn't pass. During the entire debate, while DACA was being deliberated, the president said, I don't have the power to do this, I can't do this, I can't do this. I take those statements, I think, somewhat seriously. And the second then that the bill didn't pass, is, okay, never mind, I actually have this power. The word faithful has some teeth for me, whatever that means. And he's basically saying, I discovered the power to do this after Congress said, we're not going to give you any more power. And I think there's a credible argument that's not a good faith application of executive power. Now, I'm sure the president will respond, well, my lawyers told me I can do it now. Well, that's nice. Lawyers with Republican and Democratic presidents always find justifications to do lots of things, which I would agree with. So I think it's a hard case. I don't think it's a slam dunk. I would much rather the court resolve it on statutory grounds. But I do think there is a theory of the take care clause that would push DACA in particular over the line. DAPA, I think, was a little bit more dicey. But I think you could make argument for both.
So am I hearing you correctly that you want a big component of the way you look at the take care clause looks at almost the subjective understandings or intent of the president? And when Obama said, I don't think I have the power to do that, then turns around after the bill fails in Congress and does it, that is evidence that Obama was kind of sabotaging what he had already said are the legal limits.
You know, I was citing a presidential statement before it was cool. Right now, it's so normal to cite presidential statements and judicial opinions. When I did this in 2015, I was considered controversial. That you wouldn't even look to the president's subjective statement. Now it's, of course, you look to the president's state of mind. But I think when you have a clause that says faithfully execute the laws, good faith does have some subjective component. Okay. And if you have questions, please come. I'll be able to answer them as well. Thank you so much. Very good.
Thanks for everyone coming out. I still have